This program is brought to you by Emory University.
Okay, good afternoon. I'm Reuben Guttman, and I'm here in the courtroom at the Emory University School of Law in Atlanta, Georgia, and we're talking today with Bill Nettles, who's the U.S. Attorney for South Carolina. And we've put this discussion together particularly for our colleagues in China and the class on whistleblowers that's being taught by Professor Xiao Kai and Professor Dan Guttman at Jiaotong University School of Law. So first, Bill, thank you for coming here today, and it's good to see you.
Thank you for having me.
Okay. The U.S. Attorney for South Carolina, let's talk a little bit what that job is and how you got appointed.
Sure. I think an easy way to think about it is I'm the lawyer for the federal government, and I am the chief lawyer for the federal government in South Carolina. South Carolina is a state in the southern part of the United States of America. I serve at the pleasure of the President. The President of the United States nominates me, and then my nomination goes over to the Senate, where I'm voted on, and I was confirmed by the United States Senate as unanimous confirmation. My job is, there's two major parts of my job. One is there's a criminal component. I'm the chief federal law enforcement officer for the state of South Carolina. We handle federal prosecutions in the state of South Carolina, prosecuting people who have violated federal law in the District of South or the state of South Carolina. That's our job. The other thing that we do is that we're also the lawyer. There's also a civil division of my office, and we defend the federal government. If someone is to bring a claim against the federal government, we would be the people that defend the federal government. All the agencies, the post office, Department of Defense, we defend them. There's also sort of another part underneath the civil part, and that is affirmative civil enforcement. And so we are the people that bring cases on behalf of the federal government.
How many people work for you? How many attorneys do you have in the
Got
office?
about 60 lawyers in 4 different offices.
Okay.
And we've got about 120 support staff.
And among the support staff, let's talk a little bit about what that includes. Do you have investigators?
No, we have not only we don't have criminal investigators that work for us, because the investigators, most cases are investigated by the agency when it gets to us. In other words, the FBI brings us a case, or IRS brings us a case, and then we prosecute it. Now, on the civil side, we have some investigators that'll go out and do stuff for us, but there's no investigator that works for my office. But as a matter of practice, the FBI, the DEA, they have got a lot of investigators. They investigate cases and then bring them to us.
DEA, Drug Enforcement Agency.
Drug Enforcement Agency. The EPA brings us cases, Environmental Protection Agency, the IRS, Internal Revenue Service, that would be taxes, the FBI, Federal Bureau of Investigation. Any agency that's got a criminal investigative wing can bring us a case.
Okay. With respect to the kinds of crimes that your office is involved in prosecuting, let's talk about a thumbnail sketch of what those include.
Sure. We have made it a priority in our office, and U.S. Attorney's offices across the country have made it a priority to focus on white-collar public corruption and terrorism. Those are 3 very important things to us. Prior to 9/11, terrorism was always on the radar screen. We became more acutely aware of it. And there are a lot more resources devoted to that, both at the investigative and prosecution level. So, a fair amount of our time is spent on that. But we also spend a lot of time on white collar and public corruption, and that would be financial frauds, mortgage fraud, public corruption. We've prosecuted a number of law enforcement officers, a number of political figures for illegal activity.
Okay. You've been on the job for almost 6 years, is that about right?
6 years, latter part of this week.
Okay, and I assume that you had things that you wanted to accomplish, and let's talk about what those were and how far you've gotten or how far you've come along in accomplishing those things.
I came to the job with a little bit different perspective than a lot of folks who took a job as a chief federal prosecutor in my district, in that I had spent the vast majority, my entire career until I got this job, I spent either as a plaintiff's lawyer or as a criminal defense lawyer. I started out as a public defender. I started out as someone who defended the poor on criminal charges. And then my practice always included a significant portion of criminal defense. As a matter of fact, I defended a number of individuals charged with the death penalty. I like to think that whenever I came, I brought a view that there were other ways that we could keep the citizens of South Carolina safe that didn't necessarily involve incarcerating people. And so one of the things I wanted to do was shift the focus from, the federal prosecution, whenever I got there, was we were like number 6 in the country in cracks and illegal drug prosecutions. I've shifted that focus from drug prosecution to white-collar public corruption. Among the drug prosecutions that we did, I want to develop programs so that we can start looking at not all drug cases, but more drug cases as public health issues rather than criminal issues. So in other words, starting to look at a lot of folks and saying the way that we can keep them from reoffending. One way is to lock them up forever and a day. Okay, but that's very expensive, and it has enormous impact on multi-generations. Okay, another way to do it is look at it as identifying who is an addict, and those that are addicts, utilizing the criminal justice system as a method to get them some treatment and cutting down on recidivism. So that was something we did. We set up we've got a drug court set up in every federal courthouse in District of South Carolina. We did some community-based law enforcement, which was, we had law enforcement go out and start, the goal was to have law enforcement view not as a us versus them mentality, but as their goal was to protect the community. And we started identifying who were the real problem people in the community as opposed to sort of collateral folks. And that was something that was, that Dateline did a special on-call intersection that was we now got going all over the state. That's on the criminal side. On the civil side, one of the things I really wanted to do was get an active false claims practice started. Whenever I got to South Carolina, I had 2 extraordinary lawyers doing false claims. But we just needed more resources put into it. I still have those same 2 extraordinary lawyers doing false claims, but we've added 5 more. So now we've got a total of 7 lawyers doing false claims in South Carolina. I've more than doubled the resources for false claims in our district. And, we have gone from at the bottom of the districts in terms of recovery to one of the top 10 districts in terms of recovery on false claims cases.
In the entire United States?
In the entire United States of America, yes.
Well, let's talk a little bit about, for our colleagues in China and, of course, across the United States and the globe, what is the False Claims Act?
The False Claims Act was started by Abraham Lincoln during the Civil War. And essentially what he realized was that he really couldn't, the best way to get a handle on and to stop people that were stealing from the government. So anytime you've got a war going on, you've got a lot of federal money going into private hands, right? So he had this war going on, this civil war going on. And he knew that people were stealing from the government. They were making false claims to the government. They were falsely saying they'd done something, falsely saying they provided something. So he established it so that if someone who worked for one of these companies that was stealing from the government, either through a false claim, that if you came to the government and told the government about it, that being the individual who had worked for the company that was stealing, or what we'll call the relator going forward, that relator could get a portion of the money that the government recovered from the person that was stealing from. President Barack Obama signed into law even more aggressive and better False Claims Act. And we have seen a huge increase in number of people that are bringing to our attention, like an employee works for a company and finds out that their that their employer is stealing from the government, that employee comes to us, and if we take a look at it, and if we decide to get involved in the case or intervene, then we will give them part of the money that we recover. And the recoveries can be pretty substantial. They can be up to treble damages of the singles, plus $5,500 to $11,000 per false claims. So you can see how this could easily wind up being, in the several millions, if not billions of dollars.
You use the word relator. Is that the same as a whistleblower?
That is the same as a whistleblower, and a lot of people, think of them as whistleblowers, and that's what they are. And that term comes from the fact that they blow the whistle on the illegal activity. They're working for a company. They see that, the company is promising the government they're giving them X, but they're giving them something that's Y, that costs less or is of less quality. Or they just out and out lie about what they're doing. And so anybody that is lying to the government about the services they are providing, and an employer finds out about it or realizes it, they can blow the whistle and become a relator and receive a substantial sum of the money that gets recovered.
Okay, let's talk about the process and how you
Sure.
get involved, okay?
Sure.
There's a whistleblower and he works in a workplace and the employer is providing, let's say, Jeeps to the United States Army.
Right.
And the engines don't work. And the
Right.
employee, he knows that the engines don't work.
Or substandard. I mean, let's say they work, get a better example, but let's say there's supposed to be a 6-cylinder engine in there and they're only putting 4-cylinder engines in it. Or they're warranting that the engine will work under these conditions, this type of cold or this type of heat, and the employee knows, that they're not of that standard.
Okay. And the employee finds a lawyer and files, and brings this information to your attention.
That's right.
First, right?
That's right.
And files a lawsuit.
That's right.
Right. And your office will meet with the lawyer and the employee. Does that happen, and what's that like?
Yeah, so the case comes to us and is under seal. So in other words, the company doesn't know that the federal government is looking at them yet, right? That's for a whole bunch of reasons. One, it protects the relator. Two, it protects the company, okay? Because, you wouldn't want all this getting out unless there was really something there. So the relator files a complaint making the allegations. We will sit down and meet with the relator and their lawyer. And then we can issue something called a criminal investigative demand. In other words, we can then get documents that help us to make up our mind. All right?
Okay. Let's talk about that first meeting.
Right.
Okay. Who's at the meeting on representing the government or on behalf of the government?
Well, there would typically be an investigative agency that is associated with the agency that it's being alleged they are being stolen from. So, for instance, in this case, Department of Defense would be the people that would be getting stolen from on the case of Jeeps.
Okay.
There would be an investigator there from the Department of Defense Office of Inspector General. Okay, they carry a badge and a gun, which is important because then anytime they go interview people, the people that are being interviewed have to tell the truth or they subject themselves to 1001. It's illegal to lie to a federal agent.
Okay. 18 U.S.C. 1001, is that what you're talking about?
Yeah, that's right.
Okay.
18 U.S.C. 1001.
And for our colleagues in China, that's a federal statute, and it makes it illegal to do what specifically?
To lie about something that matters, something that's material to a federal agent.
Okay. So at that first meeting with the whistleblower, there's going to be representatives of the agency's Office of Inspector General, at least, somebody with a gun and a badge, as
That's
you
right.
said. So
That's
we
right.
trigger 1001
That's right.
liability.
That's right.
And the whistleblower is on notice that he or she has to tell the truth.
And the whistleblower has to tell the truth as well. That's right. The whistleblower's lawyer.
Whistleblower's lawyer.
There will, obviously there'll be a lawyer from my office there,
Mm-hmm.
or from the U.S. Attorney's office where it's being filed. A lot of times in our office, we will bring in someone from the criminal side of the office to determine whether the company is also engaged in criminal activity. So there have been several occasions where there's been a whistleblower has brought us a case on the civil side. We've looked at it from the criminal perspective and determined there was criminal wrongdoing as well. That's called a parallel prosecution. We'd be prosecuting both the civil and the criminal case parallelly.
Okay, and do the folks in your office, the attorneys in your office who are on the civil side, do they coordinate or work with the attorneys on the criminal side?
Yes.
And are they, when they do that, are they deemed to be what is known as cross-designated?
Cross-designated. That's where it starts to get a little bit tricky, right? So what goes on in the grand jury is secret, okay? So if the criminal side convenes a grand jury, the criminal cannot tell the civil about what's going on in the grand jury, but the civil can share all their information with criminal.
Okay, grand jury, that's a whole new concept. Now let's talk about that for
Yeah.
a second. What is the grand jury, and in a sort of thumbnail sketch, how does that work in the United States?
So the grand jury is an investigative jury, and they can take testimony under oath that it's illegal to lie to the grand jury. So what it allows us is a vehicle to bring people in, put them under oath, ask them questions about an allegation, a criminal allegation, to get truthful testimony, which would then help us to decide whether to go forward or not.
Go forward on the criminal side?
Go decide on the criminal side.
Okay. Going forward means that you would issue an indictment.
We would then, so if at the end of the grand jury, okay, at the conclusion of the grand jury portion of the investigation of a case, if we've looked at all the evidence that we've got, we've decided this person, in our opinion, beyond a reasonable doubt, has committed a crime, we would then ask the jury to issue an indictment. That indictment would contain the allegations that have been levied against the individual. Now, the reason it's done in secret is because there are times where we do an investigation and we determine that there's no criminal wrongdoing. So if it weren't done in secret, then the person's reputation would be ruined and there was nothing there. Does that make sense?
Yeah, so part of the process is protecting people.
Absolutely. And that's what people don't realize is that the reason that it's secret is because it would be wrong if the word got out that the government was investigating someone and then ultimately found there was nothing there. I mean, their reputation, you can't get your reputation back. So there is a reason that it's done in secret, and that is to protect the innocent that may be, investigated but found to be cleared.
Okay, well, let's talk again about our Jeep example.
Okay.
We have specifications that you're supposed to provide a Jeep to the United States government that has 8 cylinders. There's a certification that it has 8, but in fact it has 6.
Right.
Okay.
Or there's a certification that you're supposed to have a certain grade of metal in the body of the Jeep, but it's a lesser grade of metal.
Okay. And you've determined that in addition to the possibility that there's been a misrepresentation that causes the False Claims Act to be implicated, there's a straight up fraud on the government, which
Right.
Implicates criminal liability.
Right.
Does the information that you collect through the grand jury proceeding, can that information also be used for civil pursuit under the False Claims Act? Or is that a complicated question?
Well, I mean, once there's been an indictment, okay, and that becomes part of discovery, yes. But not until there's been an indictment. And if there is no indictment, then no, it never comes out.
Okay. Let's move over and talk about the other half. We were talking a little about the criminal side. Let's talk about the civil side.
Okay.
What are the investigatory tools that your office has, that the Department of Justice has, that the agencies have
Right.
to investigate false claims allegations?
Typically, in most civil cases, the filing of the complaint and being a party to the action triggers your ability to do depositions, interrogatories, right? What's different about the False Claims Act is that during the initial period, so the relator or whistleblower brings us a complaint, we take a look at it, and then we decide we have 90 days under seal to decide whether we want to get in the case or not. During that 90 days, we can issue what's called a CID, a civil investigative demand. So we can issue to the company, give us the following documents. we can take depositions prior to deciding whether we're even going to get into the case or not, right? That works both to the benefit of, sometimes we have an obligation to investigate every whistleblower complaint that gets brought to us. Sometimes they're not any good, right? So there are times that much like is somewhat analogous to a grand jury, that the companies are glad it's under seal. Because if we can get it resolved before it comes out from underneath seal, then, their reputation is not sullied, okay? It's sort of analogous to the grand jury situation. But during that period before we actually get into the case and before it comes out from under seal, we can do CIDs, we can do depositions, and then we can make a decision about whether we are actually going to join and file a complaint with the relator.
The whistleblower, when the whistleblower comes to you, he or she sometimes gives you a list of witnesses. Is that
Right?
okay? Do you then send people out,
Yes.
agents, to
Yes.
interview the witnesses?
Yes.
And what's that like? How does that work?
Well, that is where, like when we talked about, if it's the Department of Defense, they've got an investigative wing. And someone from the Department of Defense, OIG, Office of Inspector General, will go out and interview the witnesses that the relator thinks might be relevant to the claim.
And they actually knock on doors.
They actually knock on doors, schedule, sometimes they just knock on doors, sometimes they schedule appointments, but they go out and take a statement from these individuals, so we've got an idea about what they're
And when
saying.
they take a statement, do they say to the individual, "We're here to investigate the allegations of John Smith, who's
No,
brought to us"?
no, they just go out and ask, we need to ask you some questions about, how many cylinders are in the Jeeps. They ask the relevant questions. As with any civil case, few people have all the evidence. And so what you have to do is you have to get these many different individuals to tell the story. And so they would go out and get the piece of information that we think is relevant for them.
Okay. So the Justice Department, your office, the U.S. Attorney's Office for South Carolina, investigates the case with the agency, right?
Right.
And your office, the folks in your office, the 2 or 3 attorneys working on the case, or 5 attorneys working on your case in your office, to say, this is one heck of a case, we really would like to bring it. Can you bring that case without the agency's approval?
You can, but it's rough. It's rough. And I suppose there's a way that happens, but it's rough.
I've heard some U.S. attorneys say to me that the agency is our client. Is that the way the Justice Department looks at it sometimes?
No. They are, as a practical matter, if the agency doesn't think that it's illegal, it's just difficult to get, it's not impossible, but it becomes a hurdle to showing that there was a wrong.
Okay.
But like I said, I'm not saying that it's a de facto bar, but it's difficult.
Okay. Let's talk about the process by which you decide to, you say, intervene in a case, right? First of all, before we get to, what does intervene mean? What does it mean to intervene in a case?
Intervene means that the federal government, that the federal government takes the case and goes forward. Now, one of the things that I've done, a model that I've done, there are a lot of districts heretofore, and still many that do it this way. You bring them a complaint. They read your complaint. They go, "We like this complaint. We'll take this case. We'll call you when it's over," right? We have taken a different tack, which is, I expect Relators Counsel to be partners with us going forward, okay, and working with us going forward. But if we intervene in a case, it means the federal government is taking the case. We will work with Relators Counsel, and I rely on good Relators Counsel a lot, and then we will go forward in pursuing the claim.
Okay. The process to intervene in the case, I assume somebody has to write a memo, you sit around, you talk about it, you say this is a good thing to do.
Yeah, well, basically what happens is, it depends on the case. Really big cases, we have to get approval from Washington. Sometimes Washington delegates the case to us, which means we get to make all the decisions. But, a really big cases, we have to get approval from Washington. But they give us enormous deference, and I have to say that, the administration we've got now, that we've had, good success. And I like to think some of that has to do with the fact that they recognize that we're a district that we know what we're doing. And we have proven ourselves to have good judgment in terms of what are good cases and what aren't.
So you mentioned this idea of working with Relators Council, this kind of public-private partnership for these cases.
I love it. I think it's a great idea.
Let's talk about that.
Sure. Well, so like I said, I think that probably 6 years ago, the vast majority of false claims cases that were brought, it was basically Relators Council, got contacted by the whistleblower, the relator, and they drafted up a complaint. They brought in, they sat down, they met with the government. The government did their due diligence. They issued their CIDs. They gathered their information. And then they said, we're going to take this case. And then essentially what the government was looking for the Relators Council to do was stay out of the way until the government got the case settled. And then they would come back and talk about how much money they were going to, what percentage of the recovery they were going to give to the relator and Relators Council.
Okay.
I came to Department of Justice having done some class action mass tort work. And I recognize the collaborative effect of, now, class action and mass tort, you don't have the government and private lawyers working together, but you have a group of private lawyers coming together to battle, a large corporation, right? And that had a leveling effect on the fight. I came in with the idea that taking that model, that rejecting the model of relator just giving us a complaint, you go away, we'll let you know, but saying, now listen, we could use the help. And so in good cases with good Relators Council, that know what they're doing, that have resources, that are willing to help, we have been willing to share the burden with them. Now, we have rewarded them by increasing their share, advocating for increasing their share of recovery. That has been a model that we have been advocating for vigorously. And I'd like to think that more and more U.S. attorneys' offices are beginning to advocate it. But I just felt that this whole notion of a public-private partnership enabled me to leverage my resources to do bigger and more cases than I would do if I rejected the help from private counsel.
Well, let's talk about some of your success stories.
All right, I like that.
Okay, good. Good.
We've shared a number of them, haven't we?
Well, it's been something.
Yeah.
What are the cases you like to talk about?
Well, the Robosigning case was, we got brought a case by you and your relator of a case where a woman, it's an extraordinary story, a woman whose mother had fallen in bad health. She had astronomical health care bills. She had essentially really slowed down her practice, her work, in order to take care of her mother. And this woman, Lynn Smoniak, was in the process of losing her house, of being evicted from her house. And she just started to realize that the foreclosure documents were all signed by the same people. And she then realized, through help with her lawyer, that what was happening was they were doing a robo-signing of documents. In other words, they were making up documents to expedite the foreclosure process. And you brought that. You as a relator brought that case to us, and it was a case that really was one of the first cases that that really brought us into the big time of false claims work. And we got an opportunity to play at a really. They may have done some other ones before, but this was really sort of the beginning of the beginning for the big work that we've done since then. Was that case, and it was a part of the bank settlement. $95 million. And I think that it impacted the way that foreclosures are done in this country. And, because, what they were doing was shortening the time between the time that a foreclosure was started and the time that the foreclosure was able to be executed. And shortening that time meant that people had less time to make things right. And so I would like to think that by extending the period of time that it takes to actually foreclose on a house, that people will be able to stay in their houses that otherwise would.
There's actually a book coming out in a couple of weeks which talks about this.
Really?
Which documents some of this case. Yeah.
Okay, yeah.
You should be really proud.
Yeah, I mean, I'm proud of it. I mean, I think there are people that will get to stay in their houses that otherwise wouldn't have because we made the system work right.
Okay. So that's financial fraud. Let's talk about some other examples.
Yeah, this is a pretty interesting one. One of the other ones that we recently settled was two individuals that were they were naturalized citizens, but fairly recently naturalized, and they were working in a warehouse, and they had been represented by a lawyer in town who was just a good, hard-working lawyer named Bert Louthian, had represented them on a wreck case. And they just thought he was a good lawyer and someone they trusted. And they became, these two, this father, son, and they were from Guatemala, and they became aware that the company that they worked for, who had a contract moving military, people that are in the military, when they get moved from one military station to another, that they were lying about how much the crates weighed. And they were saying they weighed more than they did so that the company could recover more money. All right, if that makes sense?
Yes.
They really didn't know about the False Claims Act, but they just knew that it was wrong. And they came to this lawyer and said, Mr. Louthian, we just trust you. And we're worried that one day somebody's going to come in and realize that this illegal, we think this is illegal, is going on, and we just want someone we trust to know about it. Well, they wound up being relators and whistleblowers, and they wound up, recovering a substantial amount of money. I think about recovered a total of about $7 million. So they got, several $100,000.
That's an extraordinary result.
It's a great story. It's a great story. And, the other thing I want to talk about is this. If you're a whistleblower in America, you get protections on your job. So they can't fire you for being a whistleblower. Now, if they do, there's a whole nother cause of action out there for wrongful termination. So, the whistleblower statute contemplates that one of the first things that a company would do about someone who is shedding light on illegal activity they're engaged in is to fire them. And so that becomes a whole other separate cause of action.
Anything in the healthcare area that you can think of?
We've done a lot of healthcare stuff. We've done a lot of pharmaceutical stuff. And, some of the Amgen cases that y'all brought us have been good. We're very lucky that we've got, of the 7 false claims lawyers that we've got one lawyer that is a registered nurse. Mm-hmm. So it puts her in an extraordinary position to be able to evaluate cases. We've got one lawyer that was a former pharmaceutical representative, mm-hmm. puts her in an enormous position to be able to talk about pharmaceutical sales. And then we've got another that has got a master's in healthcare. So we've done a lot. I mean, drug names are constantly confusing to me, but we've done a lot of healthcare litigation.
The idea that you would use a whistleblower or get the help from a whistleblower to enforce the law, right? Obviously, as you said, it's not new to the American legal system,
Yeah.
right? But if you were sitting here and advising foreign countries who were promulgating new laws, do you think that they should put in whistleblower provisions in their laws to help them enforce?
Yes, and let me tell you why.
Okay.
So the easy answer is yes, of course. I think that's a great idea. And it's working very well here. Our office alone is on track to recover $100 million in recoveries this year. Now, to put that in perspective, my total budget for both criminal and civil is less than $9 million, okay? So they give me $9 million a year to run the U.S. Attorney's Office, and I'm on track to put $100 million on false claims alone back into Treasury. And let me explain to you why, and let me share with you why, and I'll wrap this up real quick, why this is very important. Take healthcare, right? A lot of what goes on in the healthcare industry is built on trust, right? People provide healthcare to citizens, and we trust that they're not going to lie when they tell us what they did, right? And so one of the ways that we can that you can check up on whether they're doing the right thing or not is you can go out and hire this whole huge bureaucracy of people that it's their only job is to go around checking on all this stuff. Well, you got to pay those people. The federal government has to pay those people. Or you can have it built in and make it so that the people that work for the companies that deal with the federal government have got a way that they can blow the whistle on illegal activity and be rewarded. Get a part of they've got a financial reason for doing so. Not only is it the right thing to do, but it's an ability to make some money. And so the other thing is the companies that do business with the federal government know that everybody that works for them is in some respect a potential investigator. And so I think that the cumulative effect is a lot less expensive way and a lot less burdensome than hiring lots of federal investigators.
The value of the False Claims Act, did you think when you started your job almost 6 years ago, being the U.S. Attorney for South Carolina, did you ever envision that you'd get those kinds of results?
Yeah, I'd never even heard of the False Claims Act before I became the U.S. Attorney, or Whistleblower Protections. I'd never even heard of it. But, the cases that y'all brought us, it very quickly became apparent to me that as I said earlier, that it was a lot like a class action, in the way that individuals were able to stand up to big corporations, was that lots of plaintiffs' lawyers got together and formed a unified front against a large corporation. And in this case, what we have is, an individual, that being a whistleblower, partnering with the United States government to go against a corporation.
Now, a whistleblower under the False Claims Act can only recover on behalf of the government damages, right?
Right.
And civil penalties.
Right.
But the government, right, can bring a suit in addition to the False Claims Act case that it can intervene on. It can seek all kinds of other relief. For example, breach of contract can bring fraud case. Could it bring an injunction case to prevent the bad behavior?
Let's put it to you this way. The relator's case is the jumping off point for us. And once we, start realize there's illegal activity going on, there's any host of avenues available to us.
You're a policy guy, right?
I'd like to think I am.
And one of the most exciting things about the False Claims Act, I think, and tell me if you agree with this, is that while initially it's about recovering money for the government, it also really is about changing behavior.
Oh yeah. Well, absolutely. It is a way that, people are in business to make money, all right? So what they understand is money. And if you can, make it so that they realize that now, let's be clear, if they cheat and they get caught, treble damages, okay, so that's, for every $1 they stole from the government, they got to give $3 back, okay? And every single claim that they lied about, it cost them between $5,500 and $11,000. So, very quickly they can start to see how this adds up. I believe that as more and more businesses start to recognize the exposure that they've got by way of employees having a financial interest in whistleblowing about fraudulent activity, that my hope is that we see less fraud in the government. Let's be clear. For instance, in the military, the more money, that we keep from being stolen is more money for Jeeps and bulletproof vests. The more money we keep from being stolen allows us to provide better health care in the healthcare arena. And so a more efficient government is a better government and makes, their people better place to live.
Let's talk about some sort of high impact areas, and tell me if you agree with me. Healthcare, standards in nursing home, a nursing home that's
Right.
paid that's reimbursed with government Medicare dollars, right? They don't staff the home properly. They don't watch the patients and care for them, right?
Right.
False Claims Act being used
Yeah.
to go after money that the government paid, but also at the end of the day, it's affecting standards of care for the elderly.
Absolutely. So, let's be clear about something. When you're in the healthcare industry, all right, and into nursing, all right, it's a pretty good deal because what you get is The federal government says, if you will abide by these standards, and they're clearly marked out, okay, if you will abide by these standards for this person, we will give you money every month, all right? And so that is a steady stream of income, regardless of this patient's wealth, all right? So it's a pretty good deal. Now, what we do is we trust them to tell the truth, that being the company. So when the company, proves himself to be untrustworthy, all right, we, the way we get their attention, so to speak, is we take their money. Right. Now, the other thing is, they have to be licensed to do this. So there's a whole nother area, which is whether the activity that they engaged in was so severe that they should no longer be licensed to do it. And that's a whole nother thing, but it's something that comes up during the course of these discussions.
Bill Nettles, thank you so much.
Thank you.
I'll leave the last word to you. Final thoughts for our colleagues in China.
It's been, I've been told that there's been a movement afoot in China for there to be some oversight from within, much like what we've done with the False Claims Act, of government fraud. It's working very well here, and I think it made an enormous impact. I think it's allowed our government to be more efficient, and I think it will continue to make our government more efficient.
Well, I know you've had an impact as the United States Attorney for the state of South Carolina, so thank you for your service.
It's been fun. Thank you.
Thank you.
Thank you.